Constitution, when it comes to the petition for the removal of the, what do you call it, Article 146, Clause 6, the petition is submitted to the President, isn't it? So if we are going by that, then that is where the petition was submitted, and that is where,
the fallacy is.
Took place.
That's what
what upsets me is that when it came to the petition, there was no integrity in providing confidentiality and sanctity to the grounds of the petition. But when it comes to the Chief Justice, her integrity must be assured, because she could also have leaked her responses, especially if the responses were saying no, no, no to each of the grounds of the petition. So in this case, I believe that we must educate the public that when you hear one-sided version of a legal matter, please keep quiet. Don't jump to conclusions, because in law, we have something called let's hear the other side. The one that, it's a long sentence in
Latin.
In Latin, audi alteram patent. But once you hear the word alteram, you know it means look at the alternative. Yeah. So please, public, if you are listening to me, when you hear a one-sided petition, keep quiet. Let's also be patient and hear the response. If the response has not come from the Chief Justice, that means the petition has been leaked, you know, in what do you call it? And it's contrary to that hearing the other side. So let's hold on there.
The question
I don't want to use the word or the
question I'm raising to you now.
So please, let's hold on when it comes to the petition.
No, so the question I'm raising to you now is
for the other side.
Okay.
Please.
So
unfortunately, the other side coming from the CJ have shown and proven integrity to the process. Okay. And I appreciate that next time there's something like that, the other side, that's the presidency, also oppose integrity.
No, your assumption is fundamentally
I'm not assuming. I'm looking at the Constitution.
No,
it's not an assumption.
Wait,
it's a constitutional basis. So please, don't use assumption. Let me give you the...
listen to me.
Article 146.
No. Yes. What I'm saying is that your assumption...
So we have establised...
constitutional...
Hold on.
It's a constitutional...
No, hold on. We have established...
You know, I'm not just presuming.
No,
Article 146.
All three before you have established that it is supposed to be a private and confidential process. So that is not a matter in argument.
Yeah, so what happened?
The question you have done, what you have done now, is a presumption or an allegation which now has to be interrogated. That has nothing to do with the provision of the Constitution.
I will say no.
So say what you want to say.
What I'm saying is that
I say no.
She's assuming
no to the presumption and absolutely no to the presumption.
You should open your you should open up your mind to what
No, I'm using a constitutional basis.
I have a constitution.
Where did the petition go to? Where was it submitted?
Is the president who wrote the petition?
So where did the petition go to? So you believe that you can look at the leakage? So wait. So are you saying that the leakage came from the people who wrote it?
Open your mind.
I'm also asking.
First of all,
is that what you are assuming?
The petition was written by somebody.
Are you also assuming?
That's the number one. Number two, the petition was forwarded to the Chief Justice. So the Chief Justice has the petition. What gives you the confidence to say that the leakage could not have come from this document sent to the Chief Justice? What gives you that?
So what are you saying?
What gives you that confidence?
So what are you saying?
How do you know?
Specific.
How do you know that it was not a Chief
I have zoomed in on what I am saying.
So what are you saying? Have not leaked it?
So tell us what you are saying. What are you suggesting?
So I'm asking you a question.
The leakage could come from the people who wrote the petition.
The presidency or the Chief Justice.
The presidency or the Chief Justice. That's what I'm telling you.
Do you agree? Do you agree that's a fair way to?
Suggestion. I have also made my suggestion. But
no, yours is not a suggestion. Yours is an allegation.
You said integrity
my
of the process.
146.
No, it has nothing to do with the Constitution. It's an allegation.
I'm not in the court of law for you to judge me. I'm telling you that this is the basis of my argument.
We all agree.
He also has his basis of his argument.
No, nobody disputes. Nobody disputes.
Exactly, but there's
nobody disputes.
I want to emphasize.
If I may be heard, nobody disputes that the process has to be confidential. And I've actually gone ahead to say that the Supreme Court says if you leak it, there can be consequences for leaking it. So all the members on this panel agree that it has to be confidential. You are the one who has said with emphasis that the petition that has been leaked was leaked from the presidency. So that is an allegation.
Well, I'm saying that if you look at Article 146.
It has nothing to do with the article.
No. Let me also learn versus clause 6.
You don't need the article to back up your allegation.
Okay? The probability of it coming from the presidency exists. There's a probability from it coming from the presidency.
Where is that?
Now,
where's the probability? Where is the probability?
Why do I have to repeat myself?
You cannot use the Constitution to back your claim.
Oh, please, then what do we use? Fantasy. The Honorable has also looked at the process and said the probability could be 3.
Okay.
I am using 1 and he's using 3.
Okay.
That could come from the office of the president or the, what do you call it? The petitioners themselves or the office of the
You did not
Chief
say
Justice.
it could come. You said it came from the presidency.
I have used that probability.
Now you change your original position.
No, why are you trying to twist my mouth?
No.
Now,
wait. Hold on. I have to moderate this show. Hold on.
Uh-huh.
Did you say it could come from the presidency or it came from the presidency?
I used the word probability.
Probability. So you are not making an exact allegation that the presidency leaked it.
What does probability mean?
I'm asking you a question if you answer that.
Why do I have to repeat myself?
You said
please,
that from the CJ's place. It is important. It is important. It is important. Please, and let me moderate this show. You said that from the end of the CJ, there's integrity. From the end of the presidency, there's no integrity. Are you changing that position?
I'm telling you that I'm still sticking to what I'm saying. That based on Article 146, Clause 6, I said the probability comes from the presidency. He says the probability could be 3. I'm saying that, well, he has brought in the 3, and so he has zoomed in on the one that I had, that there could be a probability, right? Probability that the leakage comes from the presidency. So he has more or less confirmed it.
Okay.
But let me land. But in this case, the Chief Justice has shown integrity by not putting it in the public domain, that this is my version of my response to these petitions. So I'll humbly ask the public and also add education to the public, like, please, when you hear one side on social media, let's wait for the other side. It happens in all legal situations. Whenever you file something against somebody in court, they don't rush to listen.
So let's do this. You actually truncated. You truncated Bobby.
Now I also
wait. You actually truncated. So
she just took it off.
That's okay. Sometimes it happens.
Yes, I was. Yes.
And I wanted to add.
Thank you. I would just again, for me, to the legislative reforms going forward. The constitution of the 5-member committee said 2 of them should be Supreme Court judges. Now, my practical challenge in this instance is that, and this is not definitive, just for the purposes of thoughts and discussions, if the 2 members of the Supreme Court or the 2 justices of the Supreme Court become members of this committee, and in the event that the committee at the end of their work decide that the Chief Justice is culpable in the petition and recommend that the Chief Justice should be removed. Sometimes I've been thinking, can any of these 2 members of the committee be candidates for the appointment of the Chief Justice? Of
course, why not?
Will it not suggest, like I'm saying, legislative reform, will it not suggest? Yes. If any of them ends up being appointed a Chief Justice, will it not suggest that all along there were biases through the process?
Bobby, just a
let's hear Frank. Let's hear Frank. Yes.
We are all sitting here talking about integrity.
Yeah.
And integrity got my lady friend.
You guys are supposed to be brief because Gloria is now going to have a substantive, chance.
Bobby, don't let us bring the integrity of our justices of the Supreme Court into dispute. No. Excuse me. What the inference, the inference you are making from this line of argument is that if there should be a determination that the Chief Justice ought or should be removed after the constitution of the 5-member, whatever, the 2 justices of the Supreme Court, who invariably have no choice than to sit on it because that is what the Constitution says. Is it to suggest that they will not have acted with utmost integrity and fidelity?
No, I am saying this because I'm suggesting legislative reform.
Because you see...
That is why I was making the point. Yeah, I'm saying that legislative reform...
Your point is let him finish it up.
If we are not guided by learners of the law and masters of the law, the whole process will be mutilated. Because the other 3 persons who are coming onto that committee are non-lawyers, not members of the Council of State, and they are not MPs. So this is going to come from the generality of the public. Anybody else can be appointed. Okay. But we need guidance. So, of course, it's a sticky situation. But where you have been called upon to perform a duty, we will suggest and think that there will be integrity and fidelity to the process.
I think the point I was making is that...
Hold on a second.
I think that I support what he has said in the framework of a larger constitutional
that is what I'm saying.
Reform.
Yes,
reform. Look, if we are going to safeguard the integrity of the process, it should be said that the 2 Supreme Court judges who be appointed onto the committee must not qualify to be Chief Justice.
That's what that reform. That's what I'm saying. I'm not saying that
that's what he says. So that it doesn't create the
impression. Frank is suggesting to you that implicitly
then you are
suggesting that judges can see facts
and then
which exonerate and still say these are not exculpating, facts.
I don't think it's fair.
They may even force a guilty verdict when there is no a guilty verdict.
No. What he's saying.
No, but how can you say because they have sat on the committee, they should be excluded from being appointed as Chief Justice?
That is the opportunity.
No, that is discriminatory.
No, that's the opportunity cost of sitting on the committee.
Again, all that I'm saying is for legislative reform.
It is like
going forward.
It is like you.
All that I'm saying
is those 2 persons should not come from the Supreme Court.
Perhaps that is what I'm saying. The committee, the constitution of the committee, may even be retired Supreme Court judges.
Maybe.
That is what I'm saying. So I'm talking about reform.
Thank you. Please
maybe retired Supreme Court judges.
I need you to complete your submission.
Okay, so I'm going to complete it. Yes, that's what I'm saying. No, but I didn't finish and you jumped on it. So you said yes, to take away the perceived.
I just suggested that to you.
Yes. The last,
or even retired chief.
No. I'm saying,
or even retired chief justice.
Perhaps. The last reform that I think may have to look at going forward is the suspension and the revocation. Because we know, and sometimes I think we've discussed it here, that suspension in itself is a disciplinary measure, for lack of a better word. So it is not as if it is, I have not finished my investigations, but I have suspended you. Let me finish my investigations, then I can revoke the suspension. I think that provision may also have to be looked at. Because if you say for example, you are suspending the Chief Justice, that constitutional provision does not make any room for appeal.
No.
It does not. And the Supreme Court have said that appeal is not as of right. So unless it says that you have a right of appeal, you cannot. So what it means is that the final decision, which is not only an administrative decision to be taken by the President in consultation with the Council of State, it also becomes a judicial decision. Why? Because it affects the right of a constitutionally appointed person.
But the absence of an appeal does not foreclose an action by someone who is aggrieved by the findings of
the committee.
A committee.
No, but at that time that they are suspending, the committee has not finished.
I'm not talking about that. When they are finished.
Yes, of course, when they are finished.
The product. You can question it in a court of law.
If you say that due process was not followed. But even with that, I don't know if you can question the conclusion. Again, because of the strict interpretation of the right of appeals by the Supreme Court, that if there is a specific procedure and it doesn't state that you have a right of appeal, you can appeal within so and so, you do not.
No, I'm saying you can take your mind a bit away from appeal.
And then challenge it in terms of Well, let's see. So I think, yes, it may. So after this, if this does settle, I think that the Constitutional Review Committee should have a thorough look at that Article 146 to foster the integrity of the process.
Thank you.
Yes. As we are also again allowed, suspension, does it not align with interdiction?
Actually, there is a case law which we discussed on this show that it is actually a result of a concluded process. It's loosely referred to as step aside and let me investigate.
Yes.
But once you use the word suspension, it is a punishment. I'm using punishment loosely.
Okay. So just nomenclature. Thank you.
Yes.
Thank you, Bobby. Thank you. I had the opportunity to appear before the Supreme Court, and I was saying that there was a need for rules to guide this process. They shut me down. And I told them that it might come to hurt them because they are endangered, because the process is subject to abuse. They said, well, they could protect themselves. That's fine. Yes, Gloria.
Yes. I will say humbly that we are all jumping the gun, okay? Because Ghana, we are now in a constitutional liberal democracy. In fact, if I just say constitutional, I'm limiting it because constitutional, there was once a time that we had a one-party constitution in this country, right? That was in 64. And, you know, PDA and all those Preventive Detention Acts and all those non-liberal forms of dictatorship. But now we have a constitutional liberal democracy, which is bordering on with the principles of human rights, the right to be heard, the right to freedom and all that. We have all these freedoms guaranteed and enshrined in our constitution. Now, based on our constitutional liberal democracy, I'll say that we are akin to more of the presidential system of government as practiced in the US than the parliamentary, which is practiced in the UK. Now, in the US Constitution, yes, a Chief Justice of the US, in theory, can be removed, but only through the impeachment process, okay, as Honorable said. First, there's impeachment by the House of Representatives. By a simple majority vote is needed for that. And then there's a trial in the Senate, and after the impeachment, the Senate holds a trial, a two-thirds majority is required to convict and remove the Chief Justice. But the process is very, 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 very rare. In fact, only one Supreme Court Justice, Samuel Chase, in 1804, has ever been impeached. And he was even acquitted when he went to the trial in the Senate. Why? Because the constitutional liberal democracy realizes the importance of the three arms of government. In Ghana, our constitution also recognizes the importance of the three arms of government. However, there are separate provisions for parliament, which is basically more partisan, okay? And then there are similar provisions for the Chief Justice when it comes to grounds of removal, and then the President. The President cannot be removed because we voted him into office saying he or she has a term of 4. I always say he or she has a term of 4 years. Then it comes back to the electorate. The Chief Justice also has a term of office till age 70. He or she, as has been proven.
No, the President can be impeached.
In theory, we have all the grounds here. Article 69. In theory, we have all the grounds for the Chief Justice. Article 146. But in practice, it's never done. Never, ever done. Because if we do that, then we are just shredding the foundation of our democracy into pieces. Look, in Ghana, they said the president can be impeached. These are the grounds. If he or she violates the oath of office, including doing something inimical to our economy. And that one, then we can impeach the president any time, especially after the budget reading. Then, if the proven misconduct, so incompetence, proven misconduct, and then if the person is incapacitated in mind or body. We had a president who died on the job. Nobody ever went to Parliament to say that he's he should be impeached because he's incapacitated in body and mind. The U.S. had someone who was believed to have fainted on 1 or 2 occasions, but nobody said that he should be impeached. And in the long run, when he had the opportunity and the constitutional right to go in for a second term, he said, no, I'm not going any longer. Why? Because at the end of the day, the people just want a democracy.
His party prevailed on him not to go.
Well, yes, and then the people just want democracy to prevail, okay? In Ghana, we had a similar situation. But our constitutional liberal democracy is so fragile, it's so young, that we did not even dream of asking for a president to step down for incompetence or misconduct or infirmity of body and mind.
In fact, if they breach or disobey the orders of the Supreme Court, they can also be impeached.
There are all these, and then to test my parliamentary, whatever. I mean, but the grounds, we don't even go there. So there's Chief Justice. Why are we doing that? We've had all these Chief Justices who have transcended changes in governments. We've had, even when we had the military juntas, the Chief Justices stayed on, right? They didn't touch the, well, apart from the judges who were eliminated. It's a bad history. I don't want to talk about it. I mean, that was something that we don't even want to remember in our history, unfortunately. But all the justices continued. All the courts were in operation, even though the Constitution was abrogated, political parties were banned. They were what?
Proscribed.
Proscribed. There was a ban on political activity and all that. Even the military juntas respected our judiciary. So please, let's not even jump the gun and go on and say proving misconduct. Proving misconduct by who? We've heard petitions which have been leaked in the media, but we have not heard the other side. The other side.
Okay, so for the second time you say jumping the gun. Then, I don't understand.
Yes, that. Then I also
I want to ask a question.
Oh, I'm just saying that we are talking about theory. We are, instead of the practice, we are just going on and on. You just that's what I meant by jumping the gun.
By the point you are making, you're saying that the provisions, Article 146
and 69 are similar when it comes to grounds for removal.
Okay, if I could ask the question. You're saying Article 146 should not exist?
Oh, no. Let me clarify. Article 69 concerning the grounds for removal of the president exists in theory, but in practice is never used. Likewise, Article 146 for removal of the Chief Justice exists in theory, but in practice it's never used, because at the end of the day, we are looking at the volatility of our constitutional liberal democracy. That's all I'm saying.
So if a Chief Justice does grave wrong, we should... No. I'm saying, you say the provision exists. It is intended to hold the office holder accountable. No public office holder is unaccountable, correct? The only way you can hold, perhaps, the Chief Justice accountable or a judge accountable is through this process, right?
You know what? I always liken the Chief Justice to the presidency, because it's, the judiciary, the legislature, the executive, and their heads, symbolizes the democracy. That's why on 7th January, when there's no president, briefly, for those hours when we did not have a president in office, a vice president or a speaker of parliament, briefly was the Chief Justice, the fourth, who is the, what do you call it? The symbol.
The president is elected. The Chief Justice is not elected.
Who is the symbol?
The president has powers. The Chief Justice has powers not close to that. The judges have a protection in Article 127, where the work they do, they are not liable to be sued or an action to be taken against them for an act or an omission by them in the exercise of their judicial power. So people will say, this is the only way you can exact accountability.
I will say that in practice, the symbols of our democracy are upheld in some form of aura and sanctity. And I'm still going on that. On 7th January, the fourth estate, that's the Chief Justice, was was the one. There was no power vacuum. She was the one who was in charge of the power in this country, and she had to swear in the speaker first and then the president and the vice. And even when you looked at the seating, the president and vice were, the seating was different until she swore them into office. No, all these things are symbols that are sacrosanct to
some of my viewers say you are jumping the gun. You're not sticking to the discussion present.
No, I'm explaining. It's just that you keep interrupting.
No, I'm not interrupting. I'm asking questions.
So I haven't finished. So, I'm sorry if I'm jumping the gun, but I hope they are flowing with me. I'm trying to make it as simple as possible. So we are looking at the theory and we are looking at the practice of democracy.
We have an issue at hand. If I can ask a question and expect that you will answer the question.
But I haven't landed anyway. I have one more thing to say. Fortunately, I have the chance.
Okay. My question is, we're discussing a particular issue now. That issue is that the minority or the NPP is saying that the judges, lawyers, civil society, which you will qualify to belong to, should stand up against the attempt to remove the Chief Justice. That's what we are addressing now.
Well, I was listening to on my way here, I was listening to the, what's it called? The press conference. And I heard Honorable Afenyo-Markin mention that, right? So he represents the NPP.
That's correct.
Oh, okay. I will humbly ask that he stays out of this, because with all these issues, there's also the issue of when there was a parliamentary standoff and people are saying that there was a problem with the decisions regarding the parliamentary standoff. It's such a sore point amongst a lot of the populace. So let me humbly ask that he should, he shouldn't he should not come in. He should just humbly stay away. And then let me also say that if he said it, well, I don't know if he was speaking for himself or for the whole new.
It was a party. It was a party's conference.
Well, I don't want to go into that. All I want to say is that let him stand off a bit, because there are all these issues from the standoff that happened in Parliament before the election.
Yeah, but your substantive point is that the Chief Justice should not be taken through this process.
That's my point. The Chief Justice and the President are not taken through this process. There's theory and there's practice. In practice, they are not. And then when you look at the issue of even who can be a Chief Justice, a person of high moral standing and experience and expertise, having been with the judiciary, and even with our Chief Justice also having been with the bar. These are all, what do you call it, attributes that we can be proud of, okay? And then, not only that, I know there's been a case by, I think it was the AG versus Aban, Justice Aban JSC, as he then was, and something to do with the bar protesting that they didn't want him. But the issue of how a Chief Justice is appointed, appointed and confirmed, came into being. And we know that our Chief Justices have been, as well as our presidents, have always had some authority emanating from the Constitution. So in practice, let's not even tamper with our fragile democracy by even thinking of removing a Chief Justice on petitions that have been leaked to the public, but on the integrity of her responses that are still held in
if
confidence.
A Chief Justice, on the three grounds, if a Justice of the court normally misbehaves or is said to be, if a Justice of the Superior Court misbehaves or is said to have been incompetent or is said to be incapacitated, it's okay to go through this process to remove them.
I'm not talking of that. We've had some.
No, it's a question I'm asking you.
Yes,
it's okay to use this process to remove them.
I'm telling you that in practice, we've had some processes in this country. So I don't want to go there. I remember when the Anas Amir.
I need to moderate this for
our
audience.
I'm answering your question.
You are not answering it.
I am. We all have a style of answering our question.
You're just.
I'm telling you that in answer to your question, there has been precedents about judges of the Superior Court of Judicature, I think the High Court, if I remember, and some lower courts, especially when it came to that Anas Arim case, okay? So I will say that it has happened before, but with the Chief Justice, with the Chief Justice.
It's okay to let the judges. It's okay to let the judges of the Superior Court go through the process, but the CJ should not go through it.
We have not had the justice, the CJ and the Supreme Court justice. We have not had justices of the Supreme. You know, there's a difference between the Superior Court.
So if a justice of the Supreme Court misconducts themselves, they are found to be incompetent or they are incapacitated, how should they be removed?
Where is the precedence?
I'm asking what should happen if you don't want this provision to... No, you don't want this provision to be there.
Is there a precedence? Has there been a precedence? Has it happened before? Even in the US, there was this justice who was involved, was it Clarence? I don't want to mention names. Who was involved with something about getting favors from... can you help me? I don't want to mention the name. They went in, and what came out of it?
Okay, came out I think you are understood. Thank you very much. I will. You said you are left with 1 point.
Yes, the last point
can deliver that in a minute.
The agenda. What is the agenda? Why this business of Chief Justice removal of Chief Justice? I'm wondering, is it because of Article 142 of the Constitution? Do we want to go back to a regional or public tribunal kangaroo court system? What is it? Because when you look at 1421, it says there shall be established in each region of Ghana such regional tribunals that the Chief Justice may determine. Do we want to bring the tribunals back? Do we want a Chief Justice who is pliable to allow tribunals to come in so that the people can always show their faces in our houses to search our houses? Because I heard you talking of how someone can just show their face in your house to search your house. Oh, it's conjecture. Okay, then I apologize. I thought I heard wrong. Then maybe I heard wrongly. But I'm told it's conjecture, so I'll hold my
your horses.
Yes.
Yeah. I didn't say someone can just show up in your house.
In respect to the honorable.
Let me state that clearly. I said that politicians and some commentators who are ignorant of the law or are deliberately misleading the public by saying police cannot arrest or search without a warrant. Yeah. And I was pointing to the various provisions of the law to educate the public that the police can arrest without a warrant, the police can search without a warrant, officers of law enforcement who also have powers of police can arrest, can search without a warrant under certain circumstances. And nobody should ever say that if you come to my house without a warrant, I will shoot and kill you. The only time you can use shooting to kill somebody as a defense will be when there is a question of murder.
Well, I will humbly say, okay, that under Article 18 of our constitutional liberal, our constitution, which brings in these liberal democratic principles, Article 18 says it provides for protection of privacy of home and other property. Every person has the right to own property alone or in association. No person shall be subjected to interference with the privacy of his home or property or whatever, except in accordance with law and as may be necessary.
Thank you. So you have answered the question.
I will know. So I'll humbly say that the security services and the investigative bodies should also put premium on the practice of protecting the privacy of our homes and properties, so that if you need to go to a person's home, please go through due process. Don't just say that your face alone can be a warrant to come and search a home. Please.
If somebody is committing a crime, if somebody is committing a crime, and the police or any officer sees them, they are entitled by law to arrest them.
That is totally
different. To search them. Let's not miseducate the public.
No. I won't call them miseducate.
We take a break here. We'll be right back.
Let's abide by our
I'm sorry. We take a break.
I disagree.
This is not a subject for discussion.
So please.